Hi, it's Connecticut car accident attorney Ryan McKeen here, and today I'm going to talk about one of the most important first steps that we or any car accident firm in Connecticut should take when handling your case, and that is putting your own insurance carrier on notice of a claim. Now, a lot of people, when we talk about this, they think, wait a minute, I wasn't at fault. I didn't do anything wrong. I don't want my insurance company on notice. The other guy, the person who caused this, the person who hit me, it's their insurance company that should be dealing with it. And I understand. I've been there. I was in a car accident before I was a lawyer, and I understand. I'm mad. Like, why should my insurance company be involved? I didn't do anything. And the reason is there's a lot of legal and contractual reasons why any lawyer should put your carrier on notice. I'm going to sort of talk about the parameters of the law. And the first reason is, in Connecticut, if you're in an accident, first of all, you may have a legal obligation to put your own carrier on notice. Because even though you think that the other person caused it, and maybe the police report says the other person caused it, that doesn't stop them necessarily from making a claim against you. So you may have to notify them anyway under your own policy. The second reason, and the real reason why we do it, because most of our clients, they're not really fearing that they are going to get a claim made against them as an accident, but you just never know, is that it extends the statute of limitations. And in Connecticut, the statute of limitations in what's known as an uninsured or underinsured, sometimes called UIM claim, is one of two things. It's either 3 years from the accident, or it is 6 months from when you exhaust the policy of the person who caused it. And now, Connecticut law, in order to pursue an underinsured motorist claim, you have to take all the available insurance, exhaust the policy of the person who caused it. Sometimes the policy gets exhausted very quickly. Other times it may take years to exhaust the policy. So if the policy gets exhausted in 6 months, you can make the claim, and you still have 3 years on a statute of limitations. But sometimes, in some cases, they can go for longer than 3 years. And in that instance, where the insurance company may be fighting the claim, or there may be complicated medical treatment, if it goes past 3 years and you settle with the person who caused it 3 years and 1 day later, and you have not put your own insurance carrier on notice of a claim, then you are barred by the statute of limitations from bringing it. So in my example here, 3 years and 1 day has passed. If you had put your carrier on notice, you have 6 months from the 3 years and 1 day. So that gives your lawyer time to negotiate with your insurance company and, if necessary, to file suit against them within the statute of limitations. And there's no limit to that. So it could be 10 years your case takes, and you have 10 years plus 6 months, okay? That's very unlikely. I'm just putting that out there to make a point. Cases don't usually hardly ever go on for 10 years, and I wouldn't expect a motor vehicle case would. And lastly, and this is a really, really crucial point, is under Connecticut insurance regulation, the insurance companies cannot raise your rates for an accident that is not your fault, okay? So you are no riskier, so it's not going to cause your rates to go up. And that is one of these things where a lot of people, they fear, well, if I put my carrier on notice, maybe my rates are going to go up. But that's not true. Legally, they can't do it. And if they tried to do it, we would report them to the commissioner, the insurance commissioner for the state of Connecticut, and say, this is what this company is doing. It is an unfair insurance practice. They are violating Connecticut state law. And really, in having done this for thousands of people I've done this now for my 17th year of doing this as a lawyer. I have not seen them come back and raise rates on people. Sometimes rates may raise, but it's maybe because you moved, or just in general, cars are more expensive, or a whole host of other reasons, or just the market. It's more expensive to buy insurance. but I've never seen one where it's tied to an accident that's not your fault. So understand that it's really, really important for a lawyer who's on top of what they are doing for you to immediately send out notice and not just wait and hope, 3 years down the road that you need to do it. Because, we know in our firm, if it's important, it needs to get done, and it needs to get done as quickly as possible. Well, right. And so we have letters that our paralegals send right away, and don't be scared. The insurance company may contact you and they may say, hey, we've been put on notice of a claim. Not a big deal. Send that letter to us. We will work with them. Maybe your insurance company wants a statement, maybe not. We will again work with them and handle that with you. So don't be alarmed at any of it. It is best practice. It is good practice. Your insurance company, I can tell you, they're not a friend. They're not going to be offended. They know all of this. They know exactly what we're doing legally and exactly why we're doing it. If you have any questions at all, don't hesitate to give me a call, 860-471-8333.